I want to bring in Mark Geragos now. He is a criminal defense attorney and the co-host of the Reasonable Doubt podcast with Adam Carolla. So, Mark Geragos, your reaction to this concept, like hearing Cheney Mason saying, "Don't do it, just don't tear the house down," was pretty big for me. You know, to hear a criminal defense attorney of that ilk who has defended something that high profile saying, "Don't tear this house down," seemed like a big deal. I want to get your take.
He's, I think Cheney also, who I have a great deal of respect for, is retired, is he not, Ashleigh? Because I will tell you that most defense lawyers would probably not view or voice their opinion on this, because I will tell you a secret. The last thing that the defense wants is this house to be standing, because once that house is torn down, all bets are off in terms of the prosecution. You never know, having tried scores of murder cases myself, you never know what's going to happen with a murder case. You just never, you've watched them, Ashleigh. Inevitably, something happens in the trial that nobody was expecting, either the prosecution or the defense. One of the things that you usually have is the ability to test that against a crime scene. You're able to go out. You're able to do some further investigation. How many times I've made the argument to somebody that you can't now bring in this new piece of evidence in the middle of the trial. And I've heard the judge say, Mr. Geragos, it's an ongoing investigation. Nothing stops that. Well, this stops that. You are not going to be able, the prosecution is going to hamstring themselves to exactly what their theory is. And I think, frankly, that could be a very, very significant mistake. I don't understand why the prosecution wants to do it. Mind you, I completely understand if I'm sitting. Yeah, I understand why the university wants to. I get that. I understand why the parents are divided over it. I get that also. I don't understand why the prosecution would allow this. To me, it makes absolutely no sense. And I think that they are going to, I'll make a bold prediction, that they are going to have grave regrets about that, because I think, like I said, something will transpire during the course of this trial where they wish they had that crime scene intact.
Do you see it? Because the one thing that Cheney Mason mentioned that sort of caught me off guard, because I guess I hadn't thought about it, was the appellate issues that could be raised by the defense if there's a conviction and a big piece of evidence is now missing. Do you see these appellate issues? Can you sort of prognosticate what they might be able to think through?
I can absolutely. That's why I said Cheney's retired, because I hate to kind of prognosticate, but I can think of 3 or 4 different examples of something that, without engaging in rank speculation, just something that could occur that the defense brings up in the middle of trial, that there could be an alternate suspect. There could be somebody else who was potentially a witness. There could be somebody who testifies differently at the trial than what their statement is to the police. You've got memorialized police statements, but inevitably at trial, they don't track. And if you want to test that, or you want to say, no, this couldn't be, for instance, they couldn't see from this particular angle because of this, and all you're left with are various camera angles or photos or videos that don't exactly capture that, that's a tremendous problem also for the defense, and the defense will raise that. The defense will say, we were foreclosed. We were not able to then go out and test this new theory. By the way, the prosecution never gave us this heads up. They've now introduced this piece of evidence during the trial. How are we supposed to test it? That could be an appellate issue. The prosecution at the same time is going to say something along the lines of, Judge, it's an ongoing investigation. Of course we can bring this piece of evidence in. And the defense will object and say, no, you can't, because we can't test it.
Because we can't test it. When Cheney Mason said that the House should stay standing not just through the end of the trial, but through the end of all appeals on a death penalty case, I mean, when I moved to the United States and became, a landed immigrant here, it was 28 years ago, and I covered a case in Texas of Darlie Routier. It was a death penalty case. She's still sitting on death row almost 3 decades later. So it gave me a bit of a shudder to think that the poor university and the students would have to look at this horrible eyesore for decades upon decades in a death penalty case that could have that many appeals.
Well, the problem with that argument is, and the reason I don't think that would ever stand up is that you've then got a trial presumes either an acquittal and a conviction. An appeal presumes a conviction. If you've been convicted and if you're up on appeal, and if you have not raised the particular issue with the House standing at that point, you're going to be hard-pressed to get anybody to say you got to keep that House intact during all of the appeals. So I'm not so sure I would go as far as Cheney. I will tell you that until the trial is concluded and there is a sentencing and a notice of appeal, and the trial court, once it gets to the Court of Appeal, is divested of jurisdiction, I don't think the House should be destroyed until that point of time.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.